So guys, we were discussing valid essential elements of a valid contract, and we have seen till now it has to be a bilateral one. There has to be an offer and acceptance, a valid offer and acceptance, and we have also seen consideration, that no consideration means no contract. Same way, right now we'll study one more concept. If there is no free consent, that means there is no contract. No free consent. What do you understand by term free consent? Free consent is something which is described under section 14. What is that? Section 14, free consent. And this is what we are going to discuss right now. And guys, this topic also need a detailed discussion because it's very vast in itself. What causes a free consent to be, what causes vitiate a free consent when it is said that the consent is not free. So we must be aware of the technicalities. Now, free consent. We have gone through one maxim in our last module also, that is consensus ad idem. What this consensus ad idem is, meeting of the mind, and this is quite necessary, in fact the base of making a valid agreement. Consensus ad idem. Consensus ad idem. Now guys, when your consent is free, obviously there is consensus ad idem, there is a meeting of mind. But when your consent is not free, that is influenced, that is induced by either coercion, undue influence, misrepresentation, fraud or mistake, any of these elements, then the law says that your consent is not free consent. Now, what is this coercion? It may sound, these terms may sound new to some of us, but still that is not, when we'll describe these terms, you will get to know that there's nothing new about this term and it's very common. Just the different name is used for these terms. These different legal terms are used for these activities. And what is that? Coercion. So, section 14 talks about a consent. What it says, the actual language of section 14 is a consent is said to be free, when it is not caused by. When it is not caused by what? Not caused by. By what? The first thing, your coercion. Second is when your undue influence. Okay. The third one is your misrepresentation. Okay. And the fourth one is your fraud, and the fifth one is your mistake. Fraud, and the fifth one is your mistake. Guys, what are these? These are the 5 elements which are likely to vitiate your consent. These are the elements which induce a consent which is not a free, which is not a voluntary one. So, what is the effect of these? I will definitely deal it one by one in detail, but let me tell you that all these 4 categories, even the line is not straight. All these 4 categories, coercion, undue influence, misrepresentation and fraud, that makes your contract voidable. What it makes? Voidable. And this one, mistake, a consent due to mistake makes a contract void. So, do you know the difference between void and voidable? What is voidable and what is void? While we have already seen that the contract which is enforceable at the option of one party but not at the option of other, that is a voidable contract. And who is the party on whose option the contract is not enforceable? That is, of course, the aggrieved party, whose consent was not free, whose consent is taken because of either of these. So he has a right to get the contract, to seek the contract voidable before court of law. Okay, now what is void? Void is a contract which is not at all enforceable by either of the party. So it is void ab initio. Now, let us start with the first one, coercion. Okay, now I need to erase all of these because it needs a space and I don't have a sufficient space over here. So guys, the first one we are just taking, that is coercion. Coercion, and that is obviously section 14 talks about these terms. So the very first section, section 15, talks about coercion. And now what is coercion? Let me sit and explain. Coercion, okay. What's that? Suppose just take an example. Somebody comes and put you on a pistol point and ask you to sign a paper, sign a deed. Then what would you do? Obviously, most of us, and in fact, yeah, all of us will be scared and will sign that paper out of that scare only. So what is that? Is that a valid one? Am I bound by my signature on my property paper? No, obviously not. I can move to court later on. At that moment, no doubt, I have signed my paper out of the threat, out of the pistol point threat. But later on, I may move to court and get it declared voidable, of course. Here, why? Because the consent, my consent to sign that paper was induced because of the coercion. This is what the threat, actually threat, and threat not necessarily on your person, it may be also even to your property. So any threat to your person or property is likely to cause threat. So threat is what basically if somebody threaten to do any act forbidden by law or actually commits that act forbidden by law. Like what if the person is threatening, if the person is putting you on a pistol point, he is actually committing that act. But at times when he is not having a pistol and he makes you a call that look, if you don't sign your paper, if you don't transfer your property in my name, I'm going to kidnap your child. So what is that? It's a threat to commit an act which is forbidden by law. He's not actually doing it, but actually threatening you to commit something which is not allowed by law. So this is also a coercion. And now what next? The section 15 also talks about detaining, unlawfully detaining your person or property. Okay, your property, and if even threatening to detain your property also cause coercion. Obviously, if somebody threaten us or threaten us to demolish my property, so obviously I am going to agree to enter into a contract what that other person want me to do. So this is a criteria for the coercion, and it makes you contract voidable. Now what is next? Next is your undue influence. What's that? Undue, something not desirable, okay? Undue influence. And where it is dealt? In section 16. Okay. What is this undue influence, and when, in which situation this undue influence is caused, likely to be caused? Undue influence is actually in the situation where one party is in relation to other party in a dominant position and is likely to dominate the will of the weaker party as to enter that weaker party into the contract or agreement with the dominant party. Okay, so what is the dominant position? What position can be declared that a person is in dominant position and the other person is a weaker party. So dominant position, the what most important term is dominant position. Dominant position is what? When parties are in fiduciary relationship with each other. When the parties are such that they have a relation of trust and confidence, okay? The most common example of such a contract is your contract of insurance, because contract of insurance are mostly entered out of the absolute good faith, okay? So this is a kind of relation of fiduciary relation. It's a kind of fiduciary relationship. Now in this, what else can be fiduciary relationship? Like a parent and a guardian, okay? Parent or guardian with their child. Getting? Parent or guardian with their child, a doctor with patient, and solicitor with their client, and even a spiritual guru with their devotees, or a pardanashi woman with their administrator of property or the executor. So what kind of relation you can see in these particular pairs actually, if say parent or guardian with child, or a pardanashi woman with pardanashi woman is what? The woman which is actually a woman not because of her attire only, or also because of her conduct. She is totally secluded from the society and from the social intercourse as well. So that particular woman is a pardanashi woman. Now, what is common in these relations? That these relations are such relation where there is a trust and there is a confidence. The other person relies on the dominant party in very good faith, relies on very good faith, and this is called a fiduciary relationship. Suppose, let us have an example. If a doctor is treating Mr. X, okay, if a doctor, Mr. Y is treating Mr. X for a year, and what happened? At the end of that year, Mr. X transfer his property in name of Mr. Y, the doctor, which is worth of rupees 50 lakhs just for rupees 5 lakh. Now, here the law will open its suspicious eye. What the law is going to do? Law is suspicious about this very contract of being unfair, that something undue influence was there in the patient transferring the property which is not worth of rupees 5 lakh only, that was actually worth of rupees 50 lakhs. Now what? The patient can move to the court and get it declared voidable. Obviously here, who has the liability to prove that the contract is not induced by undue influence? Obviously who? The party in dominant position. Here, in this particular example, the doctor, he is under influence, he is having a burden of proof that look, this contract was not induced because of undue influence, it was fair enough, the consent was fair enough, and also he has to prove that this transfer or this very contract is of some benefit for the doctor even. And what kind of benefit, that depends on the circumstances of each case, but he has to prove these two things. Actually, look, in this contract is also a voidable one, but because of undue influence, the court has put a burden on the dominant party, the party who is in dominant position. But in other voidable contracts, the burden is on the person who is aggrieved one, who has given the consent which was not free, so not the dominant party. So here the case is something different. Now next comes your what? We have covered fraud, we have covered coercion, we have covered undue influence. Now next we are going to talk about misrepresentation. The third criteria for free consent is, guys, these things I'm telling you because I think all of us must know what kind of consent we if we are entering into any contract, whether it's a commercial contract or personal contract or a family contract, if we can say it, we must know about the technicalities of consent, because this is the most common factor which is brought to the court in day-to-day life. The consent defense is most of the time taken if the other parties want to get their contract voidable, if they change their mind. So we must know about what causes a consent to vitiate. Okay, now we are talking about misrepresentation. Misrepresentation. And this is, in which section it is provided? We have covered section 15, we have covered section 16 also. So obviously you must think that this is what section 17, but actually this is not 17, this is 18. So section 18 talks about misrepresentation, and why I'm talking about section 18 right now and not 17, you will just get to know it a moment later. Okay, misrepresentation, what is that? Representation we know, and the word prefix mis is added to representation. Something misstatement is actually what? It is misstatement. Misstatement of what? Misstatement of fact. Okay, misstatement of fact. And what kind of fact? Fact material. Fact which are material to agreement in question. Not every fact. The fact which is material to the agreement, that is fact we are talking about in this misrepresentation. Now, what kind of misstatement? That is unintentional, without any intention to deceive. Okay, unintentional and without any intention to deceive. Now what section 18 says, that if there is a misstatement, if person makes a statement which is not true, okay, the statement made by a person is not true, but he believes it to be true. He has no actual information about that, but he believes that it is true, and this is actually not true. So what is that? This is misrepresentation, and which he believes, obviously it shows that the person is not having intention to deceive, person is not making an intentional misstatement. So this is what misrepresentation is. Now, what kind of things are necessary to establish a misstatement? So for that we have three circumstances. What's that? There has to be an unwarranted statement. There has to be what? An unwarranted statement. What is unwarranted statement? Unwarranted statement. This is number one. Unwarranted statement. Okay. What is this unwarranted statement? Suppose I have a painting which I believe is an antique painting and which is of my forefathers. And one of my friend comes and asks me about the age of that painting, and I tell him, look, it's very antique, it's very old, this is for my forefathers, and I believed it to be so. Actually, even though I have not asked my parents, I have not inquired it about with my parents, but actually I believe it to be so because I thought it looks to be antique. Okay. But now what happened later on? My friend got to know that actually it was not antique, it was just 20 years, 25 years old. When I asked my parents, obviously they told me, look, this is not of your forefathers. Your father got it from somewhere before your birth. So now what? What is this? This is actually a misrepresentation. I made a statement which was not true, but I believed it to be true. I made a statement about my painting to be an antique, which I believed it to be, but actually it was not antique. So this is an example of misstatement, a very practical example. Then also, if if I am to purchase my car, which is done 20,000 miles, but actually the car is done 50,000 miles, which I was not knowing, and I made a statement, actually a misstatement, that my car has done only 20,000 miles, then what is that? This is also a kind of misrepresentation. So this is what unwarranted, some unwarranted statement, some statement which is not true, which is not warranted by any true fact, I'm making such kind of statement. So this is what necessary for misrepresentation. Now the next one, there is a breach of duty. What's that? Breach of duty. Breach of duty is what? That there is a duty to to speak So guys, I was talking about breach of duty. And what's this breach of duty? You have seen that most of us, when we go to the hospital, not operation, and sometimes, it happens when there is a life, there is some medical complication to even us or our family members. The doctors, before going to perform surgery, they tell you lots of ifs and buts about the complications of that surgery. Now, one example I'm just telling you right now, we are discussing, guys, breach of duty. But before, as I am in habit of explaining the things with the help of the practical situation, so I'm doing it here also. Breach of duty. Here, one doctor X, okay, one Dr. X is there, and he is going to perform operation on Y, Mr. Y, okay. Now, operation, okay, what he's going to do? Mr. X, operation on Mr. Y. Now, before operation, Mr. X, the doctor, briefs a lot of things to Mr. Y about the cost, about the duration of that operation, how much he has to stay in that hospital, all these things, generally doctor brief you before any surgery. But he forgets or he does not tell the effect of the operation afterwards. He skipped that clause. Now, what happened? There was a major effect. Actually, the operation was performed. The Y consented to this operation. Obviously, before an operation, every patient has to sign the consent paper, either the patient himself or somebody on behalf of that patient. So accordingly, Y signed the operation papers. He gave his consent. The operation was performed. And what was the effect? The very effect of this operation had a loss of eyesight. Mr. Y had got a loss of eyesight. Now, what is this? There was a duty on part of the doctor to tell this to Mr. Y that, look, the operation may cause a hamper on your eyesight, but he skipped this duty. He committed a breach of this duty. And obviously, since we are talking misrepresentation, there are chances that this might, the breach of duty is, obviously it may be unintentional. But in English law, guys, this breach of duty is taken as constructive fraud. They are more strict. English law is more strict, and they called it constructive fraud, but not in India. Okay, constructive fraud, and they call it because they presume some motive is there. But actually, misrepresentation is always unintentional. So there are chances that this doctor has unintentionally, a lot of things they have to discuss, that there are chances that they may skip some clauses, but this was a material clause which was skipped. Okay, so there was loss to Mr. Y, and he filed a suit for misrepresentation, and he was successful. Then the third thing is, this is what the breach of duty is. And then third thing is mistake as to subject matter. Okay, mistake as to subject matter. Guys, I know you might not be getting my handwriting, but when I speak, just give a pause to your video and just try to correlate with my handwriting in my speech, okay? Where you don't get, guys, please give a pause. Again, take a rest, come back and listen to the video again and again so that you can get it where you doubt, okay? Now we are talking about the subject matter. What is that? Subject matter, every contract apart from the consideration, they have a subject matter for which the contract is entered into, and obviously the subject matter is of the core importance, and all the parties entering to the contract for that very subject matter expect that subject matter to be of certain value and what? And quality, of course. So can you, obviously none of us would go for something which is valueless, which is of poor quality. The first thing is that we just go to have a quality check before buying anything. So now, if there is a misrepresentation with regard to the value, the quality of that subject matter, then what? Tell me. Obviously that is also a misrepresentation, and that is also causing to vitiate that particular agreement. Now what? We are talking about mistake as to subject matter. Then how can be there a mistake with the subject matter? Obviously, the very first thing, the mistake as to the identity of the parties. Now what? Identity of the parties. So what I was telling, we were on mistake as to identity. Am I going right way? Yeah, am I out of scene? Guys, just think. Yes, this is something irrelevant I have quoted here, not relevant from this point of view. We are actually talking mistake as to subject matter. That means that there has to be some quality and obviously some value of that subject matter. Mistake as to identity, we are not talking about the parties here, so obviously it is out of scene. Now let me tell you about mistake of subject matter. I have just given you example of some painting which my friend purchased because she thought it's something antique. She's fond of antique painting or antique things, so she gave her consent to buy that painting because of its age. You know, it's ancient, it's old, that's why. But actually it was not so. For her, the quality of that very subject matter is not up to her expectation. So this is what mistake as to subject matter. Okay, obviously if you buy that car also, if you thought that to have done only 20,000 miles and actually it has done 50,000 miles, so also the subject matter, the value of that particular car does not meet your expectation, then this is also a mistake as to subject matter. Now what? The mistake as to subject matter, that has to be very material, that has to be relevant from the main crux of that agreement. Suppose, just let me tell you, if you're not clear with my words, that you will be more clear with my illustration. Now what? Sorry guys, it's taking time to erase. You know, some quality problem here also. The value of this subject matter, you know, that is, the quality is not up to my expectation, the board and the marker as well. Now what? One Mr. X. Okay, not X always, X and Y I am taking, just take A and B this time. Mr. A buys or purchases a property, a plot from Mr. X. Plot. Now while before the agreement, X told to Mr. A, no, Y told to Mr. A, here I am talking about A and B actually, okay. B told to Mr. A that look, this property is fertile, very fertile, even though Mr. A had already made it very clear to B that he was going to buy this property for a construction purpose, you know, plot for construction he was buying. But B said that this plot is also a fertile one. Now what? When later on the plot was not declared to be fertile, is it a material content to vitiate the contract? Tell me. Obviously not. The plot was taken for construction purpose, and the fertility of that plot is not material to this agreement. So here nothing to vitiate this contract. So what? Also, this misrepresentation, yes, of course, we're talking about misrepresentation, must be addressed to a particular party. If suppose I just made a general statement in a crowd, and that is a misstatement about something, and I didn't address to anybody. Now some person, Mr. X, voluntarily comes and act on my misstatement, then am I bound? No, I didn't address it to anyone. That was a general statement I made, and I just shared my information, what I felt to be true, and actually it was not. Then this is not my fault. I have not addressed it to any particular person. So what is required? That has to be addressed to a particular person. Now, what's the last point of misrepresentation? That is, if the person to whom the misrepresentation is addressed, the misstatement is addressed, had due means to discover the truth. If somebody is obviously telling you about the quality of any product or about giving any information, and I have or you have a due source to get it inquired, obviously you need to go and inquire. You're not required to sit and believe. So if you have means to discover the truth through due diligence, there also misrepresentation is of no effect. So that's it. So guys, we have covered misrepresentation, that is section 18, and now I'm coming on what? Section 17. Section 17 talks about fraud, and this is the term all of us are very familiar. Most of the time, more often in our day-to-day life, even a rickshaw wala, you can hear this term from their mouth. He has done fraud. He's a fraudulent person. Don't rely on that person, is a big fraud. So these things, he's a knave. So these things we all are familiar. Now I don't think I need to detail it much, but still I'll tell you something very basic of this. Fraud 17, section 17, what it says. It talks about intentional misrepresentation. What it says? Intentional misrepresentation. And that is why, guys, I have discussed misrepresentation first. Section 18 I thought shall be discussed first, because section 17 is intentional misrepresentation, and if you don't know the term misrepresentation, so obviously we can't even understand what is intentional misrepresentation. Now what? Here everything is done intentionally. Few points are provided under section 17 itself, which talks about that fraud. Such an act or such a statement is fraudulent. What says? If somebody makes a statement, if somebody makes a suggestion or statement which is what? Which is not true, and he had reason to believe it not to be true. What? He knows it that it was not true, but still he made that. Okay, this is first situation. I am making a statement which is not true, and I know that it is not true, which in misrepresentation I believed it to be true. I was innocent there, but here I am not innocent. I know that what I am telling is likely to deceive. My intention is to deceive the other person. Okay, then this is the first situation. The other situation is the active concealment of something. I know the fact, but still I am concealing it, because my intention is there to deceive. Active, something very active I'm doing. Okay. Then the third thing is giving a promise without any intention of performing it. Most of the time, in marriage contracts, they promise something, they take the money from the right side, and they didn't had intention to to perform the marriage. So what is that? An intention, a promise made without an intention of performing it. And then the fourth, this is a very wide concept the law has said, and it has said any other act fitted to deceive, means any kind of act which is likely to deceive, which satisfies the criteria of deceiving, that comes under the criteria of fraud. Okay, and the last, any act or omission specifically declared by law to be fraudulent. Okay, so by these two, any other act fitted or any other act declared by law, this makes the scope of fraud very wide. Okay, now what fraud is, I said that you are telling something, you are actively concealing something. Now, is that passive? There's something like passive concealment also. What is the passive concealment? I know certain fact, but I am mum. I don't speak anything. I am silent. Now, does silence amount to fraud? No, guys. Usually, in general cause, the silence does not amount to fraud. Why? Suppose, just have a example. In examination forms, most of us are filling and even have filled lots of examination forms in our college days. So what's that? We are required to give our attendance proof. They just give you examination form only if you give a commitment, if you say that yes, I am full of attendance. They have a attendance criteria. One student is not having satisfactory attendance to be eligible for examination, but despite he fills the examination form. Now, has he committed any fraud? Obviously not. He didn't say that yes or no I am having. There was not any particular column also with regard to such a clause that have you attendance criteria, have you satisfactory 75% attendance or not. There was no as such any clause. So the student filled the form. So guys, he has not committed any fraud here. It was the university to just cross-examine his document, cross-examine the all the clauses. So there's no fraud on part of that particular student. Now what? Just have another example. Okay. But it's not always. It's a special circumstance that silence is not amounting fraud, but it cannot go very far away. It's not always that you can keep mum and go away free. There are circumstances when even your silence can be taken as deceptive one. Now what? When the contract is when your contract with utmost trust and confidence, when you contract under utmost trust and confidence, the best example is your contract of insurance. Like if you're going to insure yourself against any company, and what the insurer is going to believe, he is just going to believe on what you say. And what I do, I'm going to sign an insurance agreement with insurance company. And I'm having a heart disease. Actually, even though I don't have, by God's grace, I'm not having any such disease, but just telling you a situation. There might be a situation that if I have a heart disease and I just don't disclose it to the that insurance company and die later, and I just die of heart attack. Now, will my representatives able to enforce the claim of insurance? Obviously not. There was a material fact which I didn't say anything. I just didn't disclose. Here my silence amounted to be deceptive. Now what next? Then when there's duty to speak, I hadn't speak. So this is what silence at times they amount to fraud. Okay. Now we have seen fraud and misrepresentation. So what are the similarities? Do you all find any similarities in these two terms, fraud and misrepresentation? Yeah, of course, these two terms are confusing because both of them are, misstatement, even though intentional or unintentional, but they are a misstatement. And both of them requires to be addressed to someone, there has to be address, and that requires a material fact misstatement, not any other fact. Okay, so these are the very common things about both of the term misrepresentation and fraud, but they are actually different, and the most defining criteria of their differences, one is intentional, that is fraud, and the other one is unintentional, that is misrepresentation. And there's also one more difference, that for fraud we can even have a cause of action under law of tort, but there is no cause of action for misrepresentation under law of tort. And also for misrepresentation, the course of the course of inquiring through due diligence is a good defense for misrepresentation, but not for fraud. Court takes a strict action for fraudulent things. Why? Because there is a principle that even fools are required to be protected against knaves, the dangerous persons. Okay, so guys, this was all about what we have covered: fraud, we have covered misrepresentation, and we have covered what? We have covered undue influence, and we have covered coercion also. Now what? We have to discuss the last part of free consent, section 14, that is what? Mistake. Guys, we are going to talk about mistake. I'm really sorry I have stretched this module a little bit, but the next modules are going to be very interesting, a very smooth one. Just bear it a little more. This was something to be required to be discussed in detail, that is of crucial importance. So that's why I even though I have tried to discuss it in brief. So mistake, what is this mistake and where it is discussed? Mistake also, even a school kid, even a 4-year or 3-year-old kid speaks that, oh, I'm sorry, I've done it by mistake. So what is this mistake actually? What it says? Mistake. In law, there are two kinds of mistake. Law talks about, let me clear it. It's very dirty. I have told you the quality. I'm not satisfied with the quality of this, board. But still, even I'm trying to manage. So, mistake is two types. Mistake of fact and mistake of what? Law. Now, mistake of law is defined under what? Section 20. If I'm sure. And fact is discussed under, I need to cross check the section. What is that? Mistake of, okay, I'll just come back on sections. I need to check it. Now, mistake of fact and mistake of law. Now, mistake of fact again can be divided into two parts. That is unilateral and something bilateral. Okay? Bilateral. Unilateral what? Unilateral, it's not what we have talked about unilateral parties or bilateral parties. Here I'm talking about unilateral mistake and bilateral mistake. Unilateral mistake and bilateral mistake. And this is what? Mistake of law. It can be also of two types. Law of land, that is law of your country, and this is law of foreign law. Okay, foreign law. So guys, we are talking about mistake of fact and mistake of law, but I skipped two very essential maxims, Latin maxims, on which this concept of mistake is based. Let me just write it down over here, and it's obviously going to need a space. Before I write, let me speak out those two maxims, and those two maxims are ignorantia facit excusat and ignorantia juris non excusat. What is that? Ignorantia. Obviously, the term ignorantia you can understand. Ignorantia, it sounds very much similar to ignorance. Facet. Facet is something. You can guess, it's fact. Facet. Excusat. Excusat is what? Something to be excused, worth excusing. Okay. First maxim is this, and the second maxim is ignorantia. This is, this sign I'm giving, even all of us are familiar with this sign, ignorantia juris. What is that? Ignorantia juris non excusat. Now, what is the difference here? Juris non, juris non excusat. Juris is for law and non is for no. It means, it says that ignorance of law is no excuse, but ignorance of fact is acceptable. Law you're supposed to know. This section, what? Section 21. I was confused. I'm sorry, I was confused about section 21 and 20. Now what? 20 and 22. 20 and 22. Three sections basically deal with mistake, that is section 21, 20, 21 and 22, and this 21 talks about mistake of law and this 20 and 22 talks about mistake of fact. Just let us take mistake of law first. Why mistake of law? Because the law of land is something which requires, the law presumes that a responsible citizen is supposed to know the law of land. What law of land you're supposed to know? Obviously, we have we have categorized here in two forms, law of land and foreign law. Obviously, you're supposed to know law of your land, including your personal laws. Law of land you're supposed to know, but not foreign law. In this, where is the relevancy of foreign law? Because in these modern age, we MNCs we have, we come in contract with various of foreign countries. So obviously, if we need to know the foreign laws, we need to know varieties of countries are there and with full-fledged laws. So one cannot suppose to know all the laws, because laws are very complicated. So you are supposed to know law of land only, your law. So foreign law, ignorance of foreign law, this is treated in under section 21 as mistake of fact. This is mistake of foreign law will be treated as mistake of fact only, not mistake of law. So the value about the ignorance of foreign law is not that severe, and it is taken for under eye of law as mistake of fact only, not mistake of law. Now what about mistake of law of land? Here it makes, if you just put a claim that, look, I was not aware of this law, the law does not allow you that, and there is no effect on the contract. The contract is what? Valid and enforceable. Getting, guys? So, don't even think, if you contract in a commercial field or anywhere, when you are a big professional and if you're going to contract, just never take a plea that, sorry, I was not aware of this law. Law is not going to listen you, because ignorance of law is no excuse. You are supposed to know the law and your claim will be dismissed. So here the contract will be valid and enforceable as if no mistake. Now what? Suppose if you are you have given a loan and you didn't ask for the repayment or you didn't recover it within the 3 years. 3 years, obviously, what? The time period for getting the loan back. After the 3 years, the loan becomes time barred debt. What it becomes? Time barred debt, and this is the law which everyone is supposed to know. Now, after that expiry of 3 years, you cannot take a claim that just give me back my loan. I was not aware of this law. Here, law is not going to listen you. This is what we have about law of mistake as to law. Now let's come on mistake as to fact. Mistake as to fact is again divided into unilateral mistake and then the bilateral mistake. Unilateral mistake is under section what? 22. Okay guys, and this is bilateral mistake under section 20. Now what? Unilateral mistake, where the one party is mistaken only. Okay, one party is mistaken. It can be even like as to the subject matter or as to the price of the subject matter of the contract. Most usual we just mistake one party mistake with the price. You know, sometimes you know when you go to the showroom and you bring a apparel or anything to the counter and you says you just offer, you thought that the product is of rupees 99 only, 999 only, 3 nines, and the product is actually of 4 nines. You just missed 1 9, and what's that? This is just mistake of 1 9 only, but there's a vast difference. This is 999 and actually the product was of 9,999. So one party is mistaken here. This is not going to vitiate the contract, and this is valid, again valid and enforceable. How? This is, you know, just one step more, that you got confused and you just bought that by mistake. You bought that apparel because you just most often we just put our credit card, you make payment to credit card mode, and you only get to know when the message comes. Okay, so here after that you cannot ask to refund if that particular showroom is not having a refund policy or return policy. So you cannot impose that, you know, I was mistaken with the price. They are not going to listen you, and they have a right not to listen you. Okay, this is what the unilateral mistake is. And next comes what? Bilateral mistake. Bilateral mistake is what? Let me sit and explain. Bilateral mistake is something when both the parties are mistaken. What? Both the parties are mistaken. Suppose Mr. A and Mr. B are agreeing to sell a horse which they don't know that at the time when they were agreeing the horse was dead actually. Okay, what happened? The horse was dead actually. So here both the parties, neither A nor B was aware about the existence of subject matter. So here the contract is void and not enforceable, because there was something for which they were contracting for something which is not at all in existence. So here both the parties are mistaken, and this is what? It becomes void. Okay, here the contract is not enforceable, cannot be forced to be performed. So this was all about mistake of fact and mistake of law. Now one more thing is to be that the mistake requires to be of something material to agreement, as I have discussed in misrepresentation and fraud also. Again, mistake also that is required. The mistake must be as to something very material to the contract, not very something which is not very relevant to the contract term. Okay, so this was all guys. We are done with free consent. We have covered that 5 factors like coercion, undue influence, your misrepresentation, your fraud and mistake. These 5 factors, if you give a consent or if you are taking a consent of the other party free from these factors, the consent is absolutely free, and law presumes there is a consensus ad idem, and that's a valid contract. So guys, after this there is one more element which is necessary for a valid contract, that is lawful object. This was what we were talking about, free consent, and now what next important is your lawful object. And what talks about lawful object is section 23. Lawful object. Lawful object. Section what? Section 23. Guys, I know I might get boring and it's a dry module, but still guys, it's quite necessary that you must know and you must be familiar with the do's and don'ts and the technicalities before you enter into contract. So you have to just listen. I have told you earlier also, you don't need to do anything, just sit and relax and just have your snacks as well meanwhile, if you can have. Now it's about to be, we are about to be over with this module, our third module. So lawful object, what is this? Section 23. What section 23 does is it limits the right of the person to contract in any area which he feels to do so. Like, you can, of course, if you are a major person, or if you are satisfying all the other criterias, you are of sound mind, you have a right to enter into contract of your wish, but it's not every contract which you can enter into. So this section 23 limits a criteria in which you are forbidden to contract. Now section 23, even though it mentions in its head's term only object, but it actually covers the consideration as well. It also talks about the lawful consideration as well. The term object and consideration are at times synonymous. They are not synonymous actually. At times they are same, something which is consideration is also the object in a contract, but most of the time these two things are different. How? Suppose when one Mr. X takes a loan of rupees 50,000 from Mr. B for the marriage of his daughter C, then what is that? Here the consideration is rupees 50,000, and he takes this 50,000 in lieu of a property paper, by mortgaging of property paper. So what is this? Yeah, rupees 50,000 is quite less, but if we just take it an example of the time when this act was framed, rupees 50,000 had some value. So don't go into the value or amount of that particular, just look at the example that he took rupees 50,000 in lieu of the property papers from the money lender for the purpose of marriage of his daughter. Now here, what is the consideration? Rupees 50,000, obviously 50,000 for the Mr. A, and for money lender what? The property papers. Okay, the PP I am writing here. Property papers, a consideration for the money lender, and rupees 50,000 for A, Mr. A, the father. Okay, and what is the purpose here? What is the object here? Object is secure the marriage of C. Okay, so here we can see this is the object, and what is this consideration? Even though I think it was not required, but it's better to be on safer side, to be clear with every little things. Okay, now what? This is going to cover object plus consideration as well. Now, what situations, what are lawful objects? So law says here, section 23 says here that all objects and considerations are lawful if they are not what? They have enlisted 5 or 6 points that if they don't fall in that category, they are lawful and consideration. Apart from those what provided under section 23, all other objects and considerations are lawful. Now what are those criteria? What are those situations which makes a contract unlawful, which makes a consideration or an object unlawful? That is, number 1, it's forbidden by law. Okay, forbidden by law. What? If I am contracting that look, I will kidnap the child of Mr. B, who is your enemy, if you give me rupees 5 lakhs. This is the contract for something which is forbidden by law. The trafficking of human beings or kidnapping, it's not allowed by law, it's forbidden by IPC. So here, if any contract is for this purpose or consideration, obviously this is not going to be legal one, this is not going to be lawful, and that is forbidden by law. And the second thing is, even though it's not directly forbidden by law, but if your contract is allowed, if it's of such nature that if allowed, it is going to defeat the purpose of law, very purpose of any law. Now what can be this situation? Yes, for example, the sale of arms and ammunitions are not allowed openly, obviously, but they are allowed to some licensed manufacturers or licensed dealers. Now, if somebody who wants to sell arm and ammunition and is not having the license, now if the law allows that person to sell without license, so obviously it's going to defeat the purpose of law, which has given restriction by the looking at the very nature of this contract or this object. So this is going to defeat the purpose of law. Now the next thing is, if it's a fraudulent one, if the object of consideration is itself the fraudulent one, the object of consideration is something which is likely to commit, which is for likely to commit the fraud on any other party. So this is also under a prohibited category under section 23. Now what is the next one? Next one is, if your object or consideration is what? It is injurious to the person or property of any injurious to person or property of any other person. Suppose if Suppose if A and B contract, A dealer contract with B that if you give me rupees 50,000 extra, obviously I'll help you to get I'll help you to sell the property of C, your enemy, on a very nominal lower price, which is very low from the current market rate, and I won't let C to know this. Obviously you are entering in contract which is likely to danger to harm the property of C, even though who is your enemy, but law won't allow you this. Law won't allow you to enter into something which is likely to danger the property or person of any other person. Then law also not allow you something which is immoral. The purpose or consideration, if it's immoral in nature, if it's like if it's against the spirit of the society, of the culture. Look, all of us are Indians and we have a civilized code to live. We have a code of conduct, we have a social status, we have a culture to follow. So if some contract is entered into which is against the spirit, like suppose if A gives a house to B for the purpose of gambling, it's obviously the concept of gambling is very immoral and the law won't allow you this. Then the final one is, the law also does not allow if the consideration or object of the contract is against the public policy. Now what is the against public policy? Suppose if it's likely to interfere with the administration of justice. The interference or compromising the non-compoundable offenses are not allowed if somebody agrees to restrict or withdraw the criminal proceedings for a non-compoundable offense. That is not allowed. That is against public policy and is stuck by law. Now what? Marriage brokerage contract. Such contracts are also deemed to be against the public policy and are not allowed. Also, if there is a trafficking in public offices. What is the trafficking in public offices? That is, if somebody says, look, give me rupees 5 lakhs, 25 lakhs and I will fix you a seat in government college. So is it allowed? Obviously, it is some kind of trafficking with public offices and it's not allowed by law. It's against public policy. So whatever kinds of these 5 categories, if your object or consideration fall within categories, if it's forbidden by law, if it's immoral, if it's against public policy, or if it's fraudulent, then these all contracts with such an object in consideration is void and ab initio and it is of no effect. So this was all about section 23, friends. We are done with that and now we'll come on section 29. What is that section 29? Guys, I'm telling you time and again that if you're not from a legal background, your sections are not very important for you. Just what is important is the concept, what the concept this section delivers. So now section 29 is about the certainty of meaning. Certainty of meaning. Meaning of what? Certainty of meaning of what? Obviously, meaning of terms of agreement. Whatever the agreements you're going to enter, the terms of agreement are very clear, not vague, not ambiguous, not worth measurable. What is that? Must be from either it is section 29 says either it is clear or it is capable. The terms are capable of being made certain. Either they are certain by their terms, or if not certain, they are capable of being made certain. Now, what is this capable of being and what is the certain? Just look at the example before I start. Now, suppose A agrees with B to supply 100 tons of oil. What? A agrees to B to supply 100 tons of oil. Now, what kind of oil? There are many kind of oil. Mustard oil, coconut oil, sunflower oil, and obviously olive oil. So, what kind of 100 tons of oil? This is not certain. The type of oil is not certain and it cannot even be made certain. So, this is what? This is void. This is not allowed. This is not allowed for its uncertainty. Okay. Now, if suppose this A, who is a dealer, everybody knows that he is a dealer of coconut oil. In the market, he is the exclusive dealer of the coconut oil. Now, is he required? Then again, if the dealer A is a dealer of coconut oil, he requires to mention that the 100 tons of coconut oil. No, that is implied from these circumstances that obviously if he is dealing with coconut oil, he is into the business of coconut oil only, then obviously this contract is for coconut oil. So in this situation, it is not uncertain. Okay, and that is allowed. Now, again, if there is a contract that I'll sell you 100 tons of oil for rupees 10,000 or 12,000. Two prices are mentioned by A for B, either 10,000 or 12,000, and they're not clear about which price they have exclusively agreed. So again, this contract is the terms of the agreement as to price are uncertain. So this is also not allowed. Now, the situation when A says, different situations, like situations I'm just putting up before you. A says to B that I will sell you 100 tons of oil. I'll sell you 100 tons of oil on price to be fixed by my father. On price to be fixed by whom? By A's father. Okay? On price to be fixed by A's father. Now what? Is it uncertain? No, because the price is capable of being fixed, capable of being made certain. If A's father, obviously who is the authorized person, fixes the price, the contract is made certain. So what it says, just the essence of section 29 is the contract must be certain or capable of being certain. There can be no agreement can be given a valid effect unless and until they are not certain with their terms. So this was all about section 29, guys. This was very brief. Now, the next essential criteria we'll discuss is legal formalities. This is what practically most of us be knowing. When we talk about the essentials of a valid contract or the legal document, most of us have in our mind that it must be properly signed, it must be registered, it must be witnessed. So these things only: witnessed, registered, and signed. And we are not, even a layman knows this, that a document to be valid, oh, it's not signed, it's not valid, oh, it's not duly stamped, it's not valid. They may or they may not know about valid consideration, free consent and all, but at least about this segment which I'm going to discuss, most of them are very clear. Now, what we are going to talk, it's not working properly, guys, I'm sorry. Legal formalities. Now, from where the concept of legal formalities come? Guys, just come back to the starting of module 3 when I was discussing section 10 with you all. The last part, apart from those 5 elements, the last part, the last clause of section 10 has mentioned an additional clause that nothing whatever mentioned in section 10 is to affect any law in force in India which requires a contract to be witnessed, to be registered, and to be attested. Okay, what it says that if no doubt you have to comply with whatever section 10 has provided. General cause, the law of contract does not ask for these legal formalities, but it says, it gives a permit that if any other law in India dealing with the contracts like TPA, Negotiable Instrument Act, and all those, if they require your contract, the document to be what? To be written, to be witnessed, and to be registered. Okay, then you have to comply with that. You have to get your document done with all these criteria: written, witnessed, and registered. You cannot get away with these legal formalities. Okay, so written, what is that? Even though usually what it says that under the eye of contract of law, even an oral agreement is equally good as written agreement. You don't require an agreement to be valid to be necessarily in writing. But if the very nature of contract the law asks you to have it in written form, you just please go and get it in written form. You just cannot stand and say that, look, contract act doesn't ask for, it says that it can be equally good if oral or a written, then it's valid, I'm not going to get it written. No, please, section 10 further says this also. So you have to keep it in mind and get your contract in written way. Written, most common example of a written contract is not at all working, so I don't think there's any need to write. Most common example of a written contract is what? Sale deeds. Sale deeds are more often what? They are required to be must in a written form. Then witnessed. What is that? Witnessed, a mortgage deed or the last will of a person required to be witnessed. Witnessed, why something is required to be witnessed? That is of course for evidentiary value, that somebody else who is not a party to the contract comes and comes as a proof that, look, that particular party is actually the party to contract, and the one who is signing is the person who is actually asked to authorized to sign. So this is what witnesses are required for. And I said 2 most common examples are mortgage deeds and the last will. Mortgage deed is something for, of course, when you put your immovable property in lieu of money, that is mortgage, that has to be an immovable property. And for movable, of course, we are having a pledge, embezzlement and all kind of that. So witnessed. And last will also. Last will is, the final wishes of the person with regard to the disposition of their state and property as well. So that is the last will, which also requires to be witnessed. And then the third category is it has to be registered. Registered means it has to be duly stamped, and most common example is your sale deed and gift deed. You know, the validity of sale deed or a gift deed comes into question if not duly stamped or registered. So guys, these were the three formalities which, even though your contract act does not ask, but if any other law, due to the very nature of that particular document, requires it to be written, witnessed or registered, just go for it and complete the formalities to make your document a valid and the perfect one. So guys, we are done with legal formalities, and the only one left is the last part. If you remember, I have given you here 9 points. You know, on this side here I had written section 10, and this side, the very beginning, I had written 9 points, the 9 valid essential criteria for a valid contract. So the last and the final point is not expressly declared to be void by law. Not expressly declared to be void by law. What's that? Okay, you entered into a contract that was with perfect offer, acceptance, consideration, lawful object and all, blah blah, whatever I have told you, you are done with all these. You are done with legal formalities also. But what if your contract falls with any one of this category? Section 24 to 30. Okay, this is what the list of sections provided for void agreements, you know, section 24 to 30. So even if you are done with all the legal essential elements, you have to keep in mind that you must not enter into any contract which is provided under section 24 to 30. What happens? Most often you say, I bet India is not going to win. I bet this won't happen. What is that? Is it a valid agreement? If you just say I bet and I bet, that's okay. But if you enter into particular amount agreement, if happen this, I'll give you this amount. So guys, is that valid? No, please don't enter into such kind of contract. Now what? Why? I'll tell you right now. You know, these are the few categories which law forbids that these contracts are void and not to be entered, because they are actually forbidden by law. What is the section 24 talks about? Section 24 talks about, even if your consideration you're putting in an agreement or the object is partially lawful and partially unlawful, then that partially unlawful consideration is enough to vitiate your contract, to make your contract invalid, void. Okay, so even a part of it is valid and part of it is unlawful, that's a half part or the little part of an unlawful consideration is enough to make your contract agreement invalid. So this is what section 24 talks about. And then comes section 25, which need not be discussed. We have discussed it in detail while I was discussing about valid consideration, that is section 2D and 25 as well, which said that no consideration means no contract. If a contract is without consideration, what's that? That is void ab initio. Okay, so we are done with section 25. Section 26, what it says, guys? Section 26, agreement in restraint of marriage. You know, if somebody asks a particular person not to marry a particular girl, or not, if there is any clause, you know, in the agreement that you're not supposed to marry that particular girl, or you're not supposed to marry for a particular time. So guys, these type of clauses does not make a valid clause, and it is not allowed. It is a contract in restraint of marriage which is not allowed by section 26. Now section 27, what it says? It says contract in restraint of trade. What it says? In restraint of trade is not allowed. Means you can choose, even the constitution, law of constitution gives you a right, you can choose whatever profession you like or whatever trade you want to enter into. But if there are situations when the few kind of trade requires a particular skill, particular technique. So if the restriction for that particular skill or the test or the license or permit is required for that particular skill or quality, then that is not, guys, a agreement or a contract in restraint of trade, and that is equally valid and allowed. Also, if certain trade is required to be like government fixes that kind of trade to be done by government only, that is also allowed. That is also not a restraint of trade under section 27. Now, what is section 28? Restraint of legal proceedings. Okay, restraint of legal proceedings is also not allowed. Criminal proceedings you are not at all allowed to withdraw. But suppose if you restrict a right to that, in case there is a dispute, we will not go to court of law and we will refer it to arbitration. Arbitration, of course, we might be knowing, and in the labor law, that there is a board of there's a panel of certain arbitrators. So if they reserve a right not to go before court and to go before arbitration, that is not in agreement in restraint of legal proceedings, and that is allowed. That is what section 29 talks about. Sorry, that is not section 29. Section 29 is actually about uncertain agreements. So it was about section 28, restraint of trade, and now section 29, which says for uncertain agreement. I have told you already, this is a separate criteria was there. I have mentioned uncertain agreement, that your contract to be valid must be certain, the terms of the agreement must be certain. The last one is your section 30. What it talks about? It talks about wagering agreement, and this is what I told you before when I was starting this topic. Wagering agreement, agreement entered through wager. Wager is what? Something touching an issue, either to win or lose. There is an agreement between two persons. There is a wager, by way of wager, that either to win or to lose. Most often these are entered into for the sports event, which are not allowed and they are not enforceable. So guys, please be very, very conscious while entering into a contract, and make sure your contract does not fall within any of such category. So guys, this is all about your module 3. We are done with these. We have seen many things. Now just let me quick recap those all 9 points, because it have been a long session, and there are chances that our mind might skip few of those points. So guys, at very first when we started our module 3, we discussed section 10, and 4 or 5 points were there, and then there was an additional clause regarding legal formalities, and then I just derived my 9 essential valid elements from those elements of section 10 only. Actually, those are from then I just split up those terms, and then I divided into 9 criteria, 9 elements, 9 valid elements. What were those? I just the very first thing was it needs to be bilateral. That is so simple. You cannot contract with alone with yourself. And then the next was your what? Let me sit, even I am tired a little bit. So the first one was your bilateral agreement. Then there has to be agreement with an offer, valid offer and acceptance, which we saw in details. And then we had consideration. We talked about free consent, and then we also talked about lawful object, and then we talked about competency of parties, not in details of course, which we are going to deal in our next module, and then also we talk about the certainty of the agreement and then legal formalities, and the last one, section 30. So guys, this was all along a comprehensive module. Hope you enjoy it. Even I enjoy it. Now finally, just till then, goodbye.